that is the standard, that we wish to adopt. And I mean this as a legal matter, not as a political matter. In essence, what is being suggested, as I understand the conversation, is not the direct, but the indirect criminalization of the waging of war. I make a parenthetical remark right now. I envy you. Usually, in arguments, when speaking to the fact finders, which is who you are, we say we don't envy you because the job that you have before you is so serious or so difficult. I envy you. I think you have a phenomenally hard and interesting task before you on this issue. I don't think the issue is as simple as parts of it were being discussed yesterday, which is if the waging of the war is a bad war, then one can be held liable. If it is a good war, then one will not be held liable. And I think ultimately, yesterday, Mr. Harmon, I think he may have, in some fashion, retreated from that position upon consideration in the discussion that he had with you today with regard to what is the effect of that assistance. But I go back again to now the specific case before us, because the question that you have before you is whether or not the assistance that was given had a substantial effect on the crimes. How are you to gauge that? You don't know how much ammunition they had before. You don't know how much ammunition they used. You don't know how much ammunition they received. You don't know whether or not the ammunition that was used in any respect whatsoever, and by ammunition I'm using that term in a generic sense for the moment, was in fact involved in the criminal behavior. What is being suggested is that pretty much there was a war. We've defined the war as being a bad war, not a good war. Crimes were committed. Prosecution contends that Mr. Perišić knew about some of those crimes, therefore he should be found liable. Well, I started a while ago by saying that just because you have the alarm clock in the morning and the sun rising, there isn't necessarily that causation. And you may suspect it, but that's not proof beyond a reasonable doubt. And you're being asked here, with regard to the issue of substantial assistance, to engage in conjecture, to engage in speculation, in the absence of hard evidence. And that is something I trust that you won't do. I want to move on to a discussion that was had yesterday with regard to the issue of aiding and abetting by the perpetuation of an environment of impunity, which was raised by Ms. McKenna, pages 14676 through 14677. Ms. McKenna says at line 5, however, as Mr. Harmon has set out, the form of aiding and abetting alleged in the present case is not, strictly speaking, aiding and abetting by pure omission, but rather it is aiding and abetting by encouragement. And this is a distinction made in the Brogdon appeals judgment in paragraphs 273 to 274. Well, that being the case, turning to Brogdon Appeals Chamber at 273 says, the trial chamber may have intended to imply in this case the theory of aiding and abetting by tacit approval and encouragement. An accused can be convicted for aiding and abetting a crime when it is established that his conduct amounted to tacit approval and encouragement of the crime, and that such conduct substantially contributed to the crime, citing Olaskovsky, Kayishema, and Rusindana in the footnote. This form of aiding and abetting is not, strictly speaking, criminal responsibility for omission. In the cases where this category was applied, the accused held a position of authority. He was physically present on the scene of the crime. We don't have that component. And his non-intervention was seen as tacit approval and encouragement. The trial chamber in Kashiyama and Rusindana held that the individual responsibility, pursuant to Article 6, Parent 1N Parent, brackets, that is, individual criminal responsibility under 7.1 of the tribunal statute, in brackets, is based in this instance not on a duty to act, but from the encouragement and support that might be afforded to the principles of the crime from such an omission. In such cases...
Did you say support that might be afforded to the principles?
Yes.
Or to the principles?
Principles of the crime from such an omission. In such cases, the combination of a position of authority and physical presence on the crime scene allowed the inference that non-interference by the accused actually amounted to tacit approval and encouragement. Adopting Ms. McKenna's argument based on Mr. Harmon's position, we cannot be found responsible or liable under this theory. Ms. McKenna continued, the appeals chamber has on a number of occasions acknowledged factually the encouraging effect of a superior's failure to prevent or punish. She cited to both the Celebici and the Struger appeals judgment, in which she discussed it in the context of 7-3 liability. Both of those cases were clearly in the 7-3 context. They are not in a 7-1 context, and since we seem to have been bouncing back and forth a little between the two, I think it's important to note, and I will just touch it. Mr. Lukic will be spending some time on the 7-3 component of this case, but I think that it's fair to say that the prosecution's own authority defeats the argument with regard to Perisić's liability under the theory that they have suggested of an environment of impunity. There are a couple of ideas that have been batting about throughout this trial that I think are really important to make some distinctions. One is the question of influence versus control. They don't mean the same thing. They've never meant the same thing. And in this specific case, we know they are not the same. And the reason we know that is because we received testimony on this particular issue. That testimony came from a gentleman, which requires that we go into private session.
May the chamber please move into private session. Thank you so much. Yes, Mr. Kai Smith.
I note that at line 19, I may have misspoken. If I did, I do apologize to the court reporter and to the people who are translating my words. It should be 14547, and that's lines 3 through 12. Now, the issue of influence versus control is clearly an issue that arises when dealing with the likes of Mladic. And one of the finest examples of an attempt to influence Mladic stems from the conversation that was had in between Lilic and Perisić over the question of the release of the French pilots. Because they were trying to figure out a way of essentially tricking him into working with them. And there is I'm trying to get it pulled up right now because it escapes me. There was a conversation in which they came up with a plan, that would be P886. They came up with a plan to trick him. That's influence. Now, had Perisić had control over Mladic, then he would have ordered him. Didn't do that. And this record in this trial is replete with instances of, to put it in civilian terms, what do we do with Mladic? Because nobody controlled Mladic. He controlled himself. He did what he wanted to do, he did it when he wanted to do it, and he did it from what we can tell and we submit was without regard to pretty much what anybody else wished to have occur or was interested in. I will be moving to another topic. I note the time. I suggest we take the break.
Thank you very much, Mr. Guy Smith. We'll take a break and come back tomorrow at 9 o'clock. Court adjourned.
All right.